Today with a developing story, Larimer County jurors now deliberating the fate of the man accused of starting this devastating fire last October. The fire destroyed one building and damaged another. 7 News reporter Lindsay Sablan was in the courtroom today as both sides argued their point one last time. Lindsay, the jury has a lot to consider.
They have 4 weeks of testimony and dozens of pieces of evidence to take into account. And today, as the prosecutor was giving their final fight, the suspect, Benjamin David Gilmore, seemed a little bit more on edge than usual. His lawyer even putting his head in his hands at times. And you can see the Occupy Fort Collins protester shaking his head as the prosecution tells the jury
that ripped through the penny flats last October. 7 News reporter Tyler Lopez just stepped out of the courtroom. And Tyler, the prosecution just wrapped up.
Just wrapped up the first part of it.
Gilmore took his obsession with the Occupy Fort Collins movement too far. They also pointed to a key piece of evidence, a Rolex watch found in the debris that belonged to Gilmore. The defense says Gilmore lost that watch and says it had to be someone else that was hanging
Lindsay Sablan was in the courtroom when both sides pleaded to the jury one last time. Lindsay, prosecutors say they have one key piece of evidence.
And that is a Rolex watch belonging to 30-year-old Benjamin David Gilmore that investigators found inside the Penny Flats building where this devastating fire happened.
He told the jury the defendant was knowingly setting a 20,000-foot bonfire with residents sleeping only 32 feet away. He concentrated on a $4,000 watch owned by the defendant found at the fire scene, and also talked a lot about the fact that he kept wearing black leather gloves as if to hide injuries for days after the fire. Now, the defense has answered those questions, saying that Gilmore hurt his hands in a fire incident before this blaze broke out. The defense is up now. They've got an hour.
The defense also said that Gilmore did not have a motive, but prosecutors say that is not true.
We have a man who got a little obsessed with this Occupy movement, got excited, wanted to be a part of it, was a leader in that, and with that he took it to the extreme.
Travesty. This is miscarriage of justice.
How can you work in that profession and not practice what you preach and make sure?
I think the decision had been made to blame Mr. Gilmore.
They were at the fire scene. The bike helmet and the sterno can were right next to the fire scene. And I think they should have to answer that question to the public.
The suspect that they should have processed properly and ruled out openly was Mr. Clutter, who admitted to setting the fire. That right there was enough to have a mistrial, if you ask me.
Mm-hmm. And did you feel like they even addressed how the watch was found at the fire scene?
I didn't feel like it was addressed adequately at all.
They handpicked pieces of testimony. They used the evidence. They didn't produce it all. They didn't properly handle or test evidence.
There's a perfectly valid other explanation for why this watch might have been in the residue.
What constitutes the most reliable form of the truth?
Evidence.
That they had sent to California to a lab and then said, just send it back, don't test it. Why? Why not?
That is the critical step that we failed here. Had the procedures and the methodologies of 921 been observed in the investigative stages, Benjamin Gilmore would never have been charged with this crime.
Fort Collins, Colorado. In the early morning of October 24, 2011, a 4-level apartment building under construction on the northern end of town catches fire and is engulfed in flames. Another apartment building directly next to the structure also catches fire, and residents are forced to evacuate. Firefighters are not able to contain the blaze until late the next morning. The 3 upper levels of the building are destroyed and collapse upon the first tier, which, being metal, is left standing. Several witnesses report seeing people around the site before and during the fire. Fort Collins Dispatch reports a male in a black hooded sweatshirt has been seen fleeing the area. An on-site investigation into the cause of the fire is begun immediately by the Fort Collins Police Department and Poudre Fire Authority. Members of Occupy Fort Collins, people from the homeless community, and the public at large are questioned. Occupy members are questioned with priority because of their very close proximity to the fire, as well as an apparent feud they had with Brinkman Partners, the owners of the burned building. The Occupy Fort Collins Assembly is located just east of the burned flats. An empty lot separates them from the location of the fire. During the fire, a blue shopping cart, yellow helmet, and a can of Sterno are found at the scene and collected as evidence. As they are moving and cataloging the objects, officers are approached by one Gerald Carter. He says he was previously met by officers on the west side of the camp who told him to leave the area immediately and not to take his property. The officers photograph and question him, and he is allowed to leave. Several members of the public come forward volunteering information of individuals at the Occupy Assembly claiming responsibility for the fire. Detectives locate one man, Gerardo Clutter Salazar, and he is taken in for questioning. The detective reports that Salazar is vague and contradicts himself several times. Then, of his own volition, admits to throwing Molotov cocktails during a past riot, and states that he may have told witnesses that he firebombed the building while drunk. At this time, an arson dog alerts detectives to the presence of accelerants on his clothes, shoes, and other belongings. These items are collected as evidence to be analyzed. Clutter is bought new clothes and boots, and then allowed to leave District 1 substation. He is listed as the number 1 suspect. That afternoon, while walking the scene with 2 senior employees of Brinkman Construction to get an assessment of materials in the burned buildings, the detective is told that 2 days before, one of them had seen a man in a yellow helmet pushing a blue shopping cart near the flats. Another man tells police he almost hits a person matching the description with his car. The man in the yellow helmet yelled, "I'm gonna burn this whole fucking town down." This witness is shown a picture of Gerald Carter, and he positively identifies him as the man he saw. Through the first few days of the investigation, 3 basic stories repeated by multiple witnesses begin to emerge. Number 1, that Clutter threw a Molotov into the building, A, in a drug-induced drunken stupor to bring attention to Occupy, B, to kill another homeless man that was sleeping on the 3rd floor. Number 2, Clutter and another man, Gerald Carter, each threw Molotovs. A, in a drug-induced drunken stupor to bring attention to Occupy, and B, to kill another homeless man that was sleeping on the 3rd floor. Number 3, transients sleeping on the 3rd floor accidentally started the fire with Sterno can warming fires. This scenario was repeated to officers from different witnesses multiple times who said several transients, including Gerald Carter, were sleeping on the 3rd floor. On October 28th, an expensive Rolex watch is found in the debris. Inscribed on the bezel is the name Benjamin Gilmore. It is collected as evidence.
When this watch was found, the entire investigation turned on a dime.
The investigation of the fire by the Fort Collins Police Department and the Poudre Valley Fire Authority continues for several days, and various forms of evidence is collected and tested. After the fire, insurance issues and the question of Occupy's possible involvement, the owners of the private lot ask that Occupy Fort Collins leave the premises. On November 1st, Benjamin Gilmore appeared before the Fort Collins City Council on behalf of Occupy.
Good evening, ladies and gentlemen. Sorry, I know you want to get this over with and go home. My name is Benjamin David Gilmore, and normally I'm very reserved and very quiet. But tonight, I feel compelled that I need to address you. So let me tell you a story. Imagine, if you will, a 5-year-old playing a game, playing poker. And the name of the game isn't Texas Hold'em. It's not 5-card draw. It's I win. Because he's 5 years old. Any cards he is dealt, he wins. He takes the whole pot. Mine! I win! Now everybody playing that game, of course, gets cheated, feels cheated. Because they lose their money every time. The rules always change. Imagine, if you will, we're playing Monopoly right now, and a 5-year-old is in charge of that bank. And no matter what we do, no matter what games we play, no matter what rules we play by, we always lose. We're always cheated. Because the rules always change. What do you do? What are you told to do when you're a kid by your abuse counselors? That tell you if you're not having fun playing a game anymore, when you don't like the abuse, they tell you to stop playing the game. Quit. Get out. If you're not having fun, stop. And ladies and gentlemen, that's what we're playing now. In the War of 1812, we did not, the Congress of this country did not renew the charter with the First National Bank because this was a free economy. People could use whatever they wanted to do business. They financed, they said, you either renew the charter with us or we will finance Britain to come to war with you again. They did. We won. Again, we beat the British. Our fathers, our founding fathers, warned us of a two-party system. George Washington's farewell address. He warned us of a two-party system of rivalry, blue versus red. Please stop playing this game. Allow us to be free. So I'll ask you, please, can you give the Occupy movement the permission to do what we want, to stay where we are? You give other things permission to drink, to have special events. Please, we're asking you. Let us continue. Let us be free.
Benjamin, being an educated and successful business owner, had become a recognized and outspoken member of Occupy, often bringing food and a camper to the site, as well as employing members to help him with his beekeeping and pollination company.
Are you looking for something to sweeten up your life? There's nothing sweeter than Copaco's honey. Try one of our 11 honey flavors from chocolate to strawberry. It's all natural and it's real Northern Colorado made. We have everything from beeswax candles to beekeeping supplies. Bring the family and learn all about the honeybee and our giant beehive. Copaco's honey. It's a sweet part of life.
On November 3, 2011, Benjamin Gilmore drove his vehicle up the Poudre Canyon, just to get away and think for a while. He did not realize at that time that he was being followed. He arrives at Picnic Rock Park, lights a fire, and sits in his car drinking a root beer. 3 unmarked SUVs pull in around him. Benjamin meets 3 individuals in plain clothes who identify themselves as Fort Collins Police Department. He is informed that he is being detained for questioning and must accompany them.
You know, I'd just gone to a chiropractor and I was really just trying to focus on getting better. It had been ridiculous. I've been hurt for too long and I needed to get better. And so I just headed up to Picnic Rock. I mean, it's the first public picnic area up there on the side of the highway, and just to spend some time by myself. So I just pulled in there and had some root beer with me, and I was drinking a root beer, and it was cold, so I figured I'd go start a little fire in the little barbecue pit, and really didn't turn out as well as I'd liked, because it was a lot colder up in the canyon where it's mostly covered in shadow from the canyon. And yeah, I just went back and sat in my car after starting that fire and sitting there, staring at the river, drinking that root beer, and then the police just pulled in. I mean, there was, I think it was like 3 unmarked SUVs that came in behind me, And so I started freaking out, you know. I mean, we were joking around about Monsanto and owning Blackwater at the Occupy, and so they pulled in behind me, and I was just freaked out. You know, I was like, "What are these people doing here?" So I got out and I greeted them behind my car. They introduced themselves as Fort Collins Police. I'm like, "Well, I'm in the county here, outside the city. What are Fort Collins Police doing here?" You know, they were not being honest with me. You know, why they were there and what they were doing. So I was just very on guard. I was very scared. You know, and then ultimately they told me I had to come with them, that they were going to detain me, and they were giving me like a Rule 41-1 order. That was just a detention order saying that they can detain me and collect physical evidence from me and take pictures of me. And I was like, what? I've never heard of a 41-1 in my life. What do you mean you can detain me? And I was like, no, I'm not going with you. And I'll tell you, let me talk to a lawyer and explain this to me, because I don't think this is right. I don't believe who you are. You know, your cars are all unmarked. You know, you have these badges, but you can get those anywhere. You're saying you're Fort Collins Police, but we're in the county. This does not all add up.
He is taken to the Poudre Valley Hospital, where he is shown a warrant of non-testimonial identification, requiring him to comply with certain tests. After identifying burns on his wrists, police arrest Benjamin David Gilmore. Benjamin is held for 4 months at the Larimer County Detention Center until he is able to make the $250,000 cash bond and is released with an ankle monitor. His first trial early in 2012 resulted in a hung jury. Unsatisfied, the Fort Collins District Attorney's Office makes the decision and retries Benjamin David Gilmore. His second trial began September 19th, 2013.
Or was the jury really aware that the fire at Mason Flats was never scientifically classified as arson?
No. No, I never heard anything along that line. I think we were just led to believe it was arson.
If they can convict Ben Gilmore with reasonable doubt, we're all in danger. We're all in danger of being Ben Gilmore, a suspect with no defense.
In my estimate, they were going after Benjamin and not talking about the evidence, because the evidence was clear that Benjamin was innocent.
A great leap of faith was made in that the presence of the watch on the fire scene somehow equated to the presence of Benjamin Gilmore on the fire scene.
It appears from pages and pages of written reports that somebody outside of law enforcement decided this case was going to be processed for an end result that was entirely opposite of the evidence and the facts that are extensively documented in volumes of reports.
My name is John Metters. I live in Larimer County since 2009. My profession prior to 2009 was a police officer for the California Highway Patrol. I was a police sergeant.
And how many years were you a sergeant?
28 and a half.
What kind of experience do you have in the courtroom as a result of your professional career as law enforcement officer?
Oh, geez. 28 and a half years working the road. I've been to court a whole lot. Then you go to court on civil cases and depositions. And
So have you been in federal court as well?
Yes, I have.
Can you estimate how many times you've been in federal court?
Oh, a good 5 times.
So you were present in the courtroom during jury instructions and closing arguments in the case against Benjamin Gilmore. After listening to the public defender Norman Townsend summarize how the evidence in this case was handled, what was your general impression?
His arguments were logical, clear, to the point, and I had heard the prosecuting attorney's closing arguments too. And so at that point, I was a little on shaky grounds as to what really occurred, because I told you I didn't know everything about Benjamin Gilmore's case. And so I was a little bit on shaky grounds, and I was wondering how the defense would answer some of the things that were brought up in my mind. When I heard the defense give their closing arguments, it was just crystal clear. This case it should never have been brought to this point. I can't believe it. Actually, I felt that the prosecutor should have been put on trial after I heard the closing arguments of the defense. I really did. I said, this is a travesty. This trial with all of the evidence that points to the innocence of Benjamin Gilmore. Just to have that one derelict, I forget his name, who admitted to setting the fire, that right there was enough to have a mistrial, if you ask me.
Mm-hmm.
Why didn't they have an interview of this witness? That right there is dereliction of duty, 100%. It's evidence that you need to look at, that testimony.
So in the closing arguments of the prosecution, what did you hear as their evidence that they presented in this case?
They said that Benjamin dropped his watch at the scene, and that was the big evidence. They said that Benjamin had burnt hands. The evidence did not seem concrete. It didn't seem convincing to me at all. The worst thing was the watch. I mean, come on, you don't leave your driver's license, your wallet, in a crime scene, no matter what.
As a law enforcement officer, would you look at other suspects?
As a law enforcement personnel, you should be skeptical, very skeptical of the most obvious, because it is usually not the truest of all the possibilities, because someone might be leading you down the road. And the most obvious, in this case, the watch on the ground is something that you should hold in suspect.
How do you explain that to people who haven't heard closing arguments or don't know much about this trial? How do you explain that kind of approach to an investigation where they really didn't investigate anybody except the man who owned the watch?
I don't know. I wish I could explain it right now, and I don't know. How would you?
My name is Rosemary Van Gorder. I've lived in Larimer County for over 35 years. My former occupation was a firefighter for Poudre Fire Authority. I do court watch, observing hearings and trials in both civil and criminal cases. Try to remain neutral and observe judicial conduct, along with prosecutors and even the public defenders.
So you have a lot of experience in the courtroom, observing, watching the process, and watching the system. You were present in the courtroom during Mr. Gilmore's trial in 2013.
Yes.
Did you also attend Mr. Gilmore's trial in 2012?
Yes, I did. In fact, I watched more of the first trial than I did the second. I was there almost every day. And
so you're a member of an organization called Judicial Justice. What motivated people to form that organization?
Judicial Justice was a local grassroots effort after Tim Masters sat in prison for almost 10 years for a crime he did not do. The two prosecutors who put him in prison had been appointed judges because of their fine work on that high-profile case. And these judges were up for retention. So in order to get rid of judges, we campaigned and educated the public about the problems Tim Masters' life had as a result of the prosecutors, now judges. We wanted them gone.
So Jolene Blair and Terrence Gilmore were the prosecuting attorneys in Mr. Masters' case. Then they were promoted basically to judges, and the voters decided that what they had done wrongfully against Mr. Masters was worth removing them from office.
Yes. Yes. They were, I think they should have been disbarred.
And so you're saying that in the Mr. Masters case and Mr. Gilmore's case, the evidence was similarly withheld.
Exculpatory evidence, which had the jury heard all the evidence found at the site, had they tested everything, it might have shown that they had indeed made another error with Ben Gilmore, that he was not perhaps the only suspect. A lot of evidence was really not actually evidence, but hearsay or supposition, guesswork by the investigators, putting together a case that may or may not have really been warranted by the information they had. Why Judge Odell refused to allow that taped interview to be seen by the jury is an unknown to me, and I'd like him to have to answer.
A hoodie sweatshirt, an empty sterno bottle, and a bicycle helmet with blood on it were taken as evidence but were not tested. Mr. Townsend explained to the jury that Mr. Gilmore did not know that Clutter Salazar had accelerants on his clothing. Mr. Townsend explained that the prosecution did know that Clutter had been identified at the scene by the arson dog. What are your thoughts about why the officials who were involved with this fire failed to test these items?
What are my thoughts about it? I'm shocked. I have no understanding of why they would pick and choose again about what was significant and what they didn't want to know. They were at the fire scene. The bike helmet and the sterno can were right next to the fire scene, and I think they should have to answer that question to the public. All of the experts who came in and added their 2 cents worth to come to this conclusion that because a watch belonging to one person was found on the site, obviously he did it. That's the guy. And that's where they fell down.
Prosecuting attorneys and some law enforcement officers knew that Clutter told people he was going to set the fire. Those officials knew that Clutter told people he did set the fire after the fire was already burning. And they knew that Clutter told people why he set the fire. Clutter was positively identified by an arson dog as having accelerants on his clothing. Clutter was also arrested at the scene of the fire. The Northern Colorado Regional Forensics Laboratory report listed Gerardo Clutter Salazar as the suspect in the Penny Flats Mason Flats fire. In spite of all that evidence, Clutter was released from the custody of law enforcement officers, and it was reported that Clutter died in 2012 as the result of a train accident. What is your personal opinion about why Mr. Gilmore was pursued as a suspect in this fire when all of the direct evidence indicates that Clutter is responsible for starting the fire?
It enrages me because it's just not good police work. It's a huge investment on the front end, and then trying to catch up and make the story fit with pieces here and there, when indeed they messed up by letting this guy go early and not testing his boots and clothing that they had sent to California to a lab, and then said, just send it back, don't test it. Why? Why not? Why are you going to let this man face life in prison, whatever, his whole life destroyed, for something so simple as, yes, run the tests. Let's just exclude all other suspects. A conviction is based on fact and evidence, not smoke and mirrors, not innuendo or accusations dramatized by the prosecutors to sway the jury. I just think they've made a terrible mistake again. Why we have to tolerate such an unjust system that clearly denied this man a fair trial.
And so you're a member of an organization called Judicial Justice. What motivated people to form that organization?
We wanted to remove Judges Jolene Blair and Terry Gilmore from the bench.
And what What was the reason behind that?
They were prosecutors involved in the wrong prosecution of Tim Masters.
So talk a little bit about the Timothy Masters case.
Timothy Masters was 14 or 15 years old at the time of the murder of Peggy Hedrick. Because he drew pictures and had walked by the crime scene, they thought he must have done it, so they pursued him, blindly kind of ignoring other suspects.
So in closing arguments at Mr. Gilmore's trial, the public defender, Norman Townsend, referenced the fact that prosecuting attorneys in another high-profile Larimer County case had knowledge of key pieces of evidence, but that those prosecuting attorneys withheld the evidence from the defense team. And even though Mr. Townsend didn't specifically say Timothy Masters, his reference to that case was obvious to everyone in the courtroom. So he drew the parallels between Mr. Masters' case and Mr. Gilmore's case, and he suggested that Mr. Gilmore has been a victim of that same type of prosecutorial misconduct. What's your opinion after being very familiar with Mr. Masters' case and now watching the trial in Mr. Gilmore's case? How do you see those parallels?
I guess the thing that stands out is it was brought up several times that Ben didn't call the police after he heard about another suspect saying he was going to do it, did it. His crime was he didn't report it to the police, just like Tim Masters didn't report to the police what he had seen.
Mm-hmm.
Right.
And as far as proving how the watch got there, or who put the watch there, whose responsibility is that in a criminal trial? Who is supposed to be able to prove that?
It should be the prosecution's.
Why do you think they were intent on blaming Mr. Gilmore when they had other viable suspects?
I don't understand that. It seems quite obvious that there were other suspects that were stronger suspects.
If there was one question you could have answered in this case, what would it be?
When does the search for truth end and the blind doggedness pursuit of someone else begin?
Is there anything you would like to share with the Gilmore family?
Oh, I'm sorry that this happened the way it did and turned out. There are people that do believe in his innocence.
So even though you couldn't remember what you or Ben were wearing that night, you did testify that you remembered what you did together on the night of October 25th, 2011.
Sure.
Where did you and Ben spend your time together that night?
Out back of his business, there's a river that runs through there, so we spent some time on the fishing dock, built a fire next to the fishing dock, and that was where he was decided to practice. Well, that was part of the reason for him practicing fire spinning, specifically spinning poi. That's P-O-I, and the whole idea behind that was he was doing it as he was going to perform for his wife as an anniversary present.
And why did he want to show you what he was going to do for his wife?
Because I'm his good friend, and he's proud of what he's doing, and wanted to share what he was doing. I mean, he was excited. He was he's really funny. He'll when he's happy about something, he gets like a big kid. Mm-hmm. Even nowadays as a grown adult, when he does get excited about something, while he is normally very reserved, you can see that breakthrough, and mm-hmm. It's one of his really good qualities. Actually, is the fact that he hasn't forgotten how to have fun with life, mm-hmm. and so. Yeah, that was exactly what it was. He was excited, and he wanted to, he was bursting, wanted to show somebody, and he couldn't show his wife until their anniversary, and that was, a little ways off. Mm-hmm. So,
can you describe basically what the fire spinning involves?
Well, essentially, you take a couple of lengths of chain, obviously because they're non-flammable, and attach an absorbent material to the end, and then dip that absorbent material into something that's flammable, be it alcohol, gasoline, diesel fuel, kerosene, whatever. It doesn't really matter. You ignite them and spin them. Mm-hmm. And that's. I don't do it myself, so that's. I'm sure there's a lot more to it than just my description, as with anything else like that. But that's what it comes down to.
So the fire poi chains and balls that Ben was using that night, had he made those, or did he purchase those from a dealer?
I am not sure, to be honest with you. I mean, they looked similar to say chain dog leashes, like someone would use for a small dog, that you can purchase at a hardware store or what have you. But that's not to say that that's actually where he got them. Perhaps he did purchase them, although knowing Ben, he probably made them.
So Ben asked you to help him attach the fire poi chains and balls to his wrists. Can you explain why you had to help him attach those?
He's missing fingers on one of his hands.
So, do you know which hand that he's missing?
Left, if I remember right. I mean, I'm so used to it, I don't even notice.
So, if he's missing the fingers on his left hand, then it would be difficult for him to attach the chain.
It'd be difficult for him to, yeah, because he's not going to be able to tie it. So with the one hand, he would have his fingers and his teeth. He was born this way, and so it doesn't, it doesn't slow him down. I mean.
So you helped him tie the chains to his wrists.
Yes.
What happened after you attached them? Then what did Ben do?
Dipped them in the stuff that he was or they may well have been already dipped. I don't, 2 years ago, but they would have been ignited, and then of course he started just kind of messing around with them, and then started, got him up to, got him up, started spinning, and he was doing them in opposite directions, if I remember right, at least at one point in time, and then of course sometimes in the same direction, just again playing around with them, and that was sometime after that he managed to get his hands caught up, and as he moved his hands closer together, then he managed to get his hands caught up with them and sort of bound together. And that was, and then of course the balls, hung down below his hands and burned his hands.
And so when he was stuck with the chains, there was still fire on the balls?
Yes.
And so what were the flames doing at that point?
They licked the bottom of his hands and burned them pretty good.
Because the flames are burning up?
Precisely, yes.
To his hands. What was your first reaction when you saw the fire poi twisted and stuck on his wrist?
It was my bro, so I laughed at him. I mean, so I mean, I didn't realize he was actually being hurt. I mean, I didn't. Initially, and of course he starts to holler, and and so I, did what I could to get it, help him get it untangled. Obviously, without catching myself on fire. But that was.
So after you had the burning chains off of Ben, what did you do to treat the burns on his wrists and his hands?
Cool water, hit it with some, we may have hit it with some burn cream, maybe not. It's, again, been quite some time back. And then, bandaged, dressed them, as one would, and left it at that. I mean, they were only second-degree burn. I was a Boy Scout. I can tell it first from a third-degree burn. I mean, it's very basic, know. And so, I mean, we treated it accordingly and, went back to our evening.
The prosecution attempted to link Benjamin's participation in the Burning Man Art Festival and his interest in fire spinning as an indication that he was obsessed with fire. Benjamin explained that he was burned while trying to perform a difficult maneuver known as the butterfly.
The prosecuting attorney actually had text messages between you and Ben on October 25th, 2011 that showed that you were spending the evening together, that you had planned it, that you had arranged how to get together. And in the closing arguments, the prosecuting attorney wanted the jury to believe that you never actually saw Ben that night and that the fire poi accident did not happen, even though they had used text messages showing that you had been together that evening. So
it's not an argument that I would make were I in the prosecutor's shoes. I know that.
What was the jury's verdict in the first trial that occurred in 2012?
It was a hung jury too.
A hung jury as well.
Right.
The prosecuting attorney attempted to make the jury believe that Ben was limping because he was hurt during the fire at Mason Flats on October 24th, 2011. When did you first become aware that Ben was limping from the pain he was experiencing in his hip and back? Do you remember what year that was?
2010.
2010, prior to
August 2010.
August of 2010.
The note I have for treatment of his is in August 2010.
And so the prosecution was claiming that he had just started limping because of his supposed connection to the fire, but you had been treating him for over a year.
Well, I wasn't treating him regularly because he didn't live with me.
Right.
But yeah, I treated him several times in relation to that.
Because what's the distance between his home and your home?
Oh, 5.5 to 6 hours.
Mm-hmm.
Yeah. But he was treating the other doctor. Dr. Morrison saw him several times, which is further evidence he was paying for chiropractic care. He wasn't just doing it because it felt good and it was nice.
And because you were related,
Yeah.
he got free care. He wasn't doing it for that reason. He really had a problem.
Right.
And so
well, he saw me. Maybe. I mean, you could argue he saw me because it was free, yada yada. But why did he pay Dr. Morrison too?
And Dr. Morrison is from the.
He's the
Larimer
chiropractor
County.
in Fort Collins area.
Right, and
that
he
was seeing.
testified at trial as well.
Right.
And he, Dr. Morrison, did have
better notes, hopefully. 'Cause he
medical
was getting paid.
records, and he was able to go through the dates that he treated Ben.
Right. And there was a gap. Ben told me it's like from May to October, which is great because I treated him in July and I treated him in October twice.
Mm-hmm. And this is in 2010, all in 2010, well before the fire. It
No, those were
began in
2011.
But the initial treatment began in 2010.
Yeah, the first time he
Yes.
came in was 2010.
Was Ben in an accident that caused an injury to his hip that started the...
He fell off the ladder. Yeah, that was stated a lot of times, wasn't it? And in fact, I think they left that out the second time through. The fellow that was with him when he fell off the ladders apparently testified the first time. I only know that because I was sitting outside the jury with him.
So Ben fell off a ladder during... What was he doing on the ladder?
Beekeeping of some kind. I think he was maybe trying to get one of those swarms that had gotten someone's house or something.
Mm-hmm.
I don't know exactly the nature of
Do you know
he
how
fell.
far he fell?
No, but I know he fell. I think he fell on something too, like some crates or something.
Mm-hmm.
I don't know how far he fell. I know he fell enough to hurt him really good. That's what I know.
Mm-hmm.
But the whole story is this: is like, from my understanding, it was like this was a home of the homeless. Like the owner of this building, which Ben doesn't even know really, but he gave permission for homeless people to stay there. Here's my brother trying to help the homeless people, and then he's gonna go to burn down their house. Burn down. I mean, it just totally makes no sense at all that he would do that. You know, it's like, why would he burn down the house of his friends, kind of, you know, it's like, that's what it sounded like to me to a degree.
So can you describe what kind of man Benjamin Gilmore is, his character, spirit, personality?
Well, I mean, I gave you the example with the whistle earlier. Really, he was trying to be nonviolent about things as far as, you know, I can't see that there's any way that he would choose to set a fire like this. I mean, he was trying to stand up for what was right and true, obviously. I mean, with this whole Occupy, standing up and trying to speak out and get some change to happen as far as middle-class America, I guess, we feel in the squeeze and whatnot. But I mean, he's a married man. I mean, that changed a lot. You know, you get married and he has a baby on the way. I mean, he's committed to his family. I mean, he comes from a solid family background, I think. My mom and dad are still together, albeit amazing as it may be, but you know, we're trying to follow that legacy, you know. He's been working hard to stay in the faith to a degree at least.
How have these two trials that have spanned the last 2 years impacted you and your family?
Well, you know, we're a little isolated being all the way over here on the other side of Colorado, but I know for my mom and dad the stress level's been crazy, and of course they had to finance the whole thing. That's the first time through. I can't hardly imagine it. I mean, I was falsely accused once, and I remember how upset I was, and it was just the smallest thing, you know. But the judge apologized to me. That was, at least I got an apology from a judge, you know, but he can't get anything back. I mean, the lost time, lost money. I mean, I lost a day, you know, and I was pretty upset about it, but I can't imagine for him and for the family, you know, what my mom's had to go through. I mean, yeah, it's just a hard question, so I don't know. And I don't even want to think about it.
At the city council meeting, Ben was observed limping. The prosecution asserted that Ben's injuries resulted from a fall at the fire scene. Benjamin testified that he was injured in 2010 when he fell from a ladder while working with bees. 2 chiropractors testified that he began treatment for that injury in 2010.
My education is primarily in materials engineering and metallurgical engineering. I'm also trained as a fire and explosion investigator.
So for people who are unfamiliar with the fields of material sciences and metallurgical engineering, explain what those areas of study involve.
What it involves primarily is the analysis of how engineering materials, steel, aluminum, the like, how these react to their service environment. You know, how do they react to exposure to heat, pressure, corrosive effects and such, and how do we pick the right materials for certain applications.
So how many years have you been employed in the engineering field?
I've been employed in the engineering field since 1987.
And what is forensic engineering?
Forensic engineering is the application of these same fields of study to the investigation of accidents and incidents to help determine whether or not a failure of a component, for instance, was due to inappropriate design, perhaps exposure to an environment it wasn't intended for, or simple abuse by the owner.
During the trial, the prosecuting attorney tried to discredit you because you did not have training in the criminal justice field. How does the fact that you are not a law enforcement officer impact your ability to apply scientific forensic investigation methods to a crime scene?
It doesn't.
Just straight out does not impact your ability to investigate a crime
No.
scene?
The ability to investigate a crime scene is rooted in scientific principles, and I'm extensively trained as a scientist.
Mm-hmm. Approximately how many different cases have you been called to testify as a witness?
There are two different types of testimony. You can be called to testify in a deposition. I've probably done that 50 or 60 times. Trial is far more rare, probably a dozen or so.
Mm. You testified at trial that you have been retained in a fraction of cases where the findings are substantially at odds with the alleged facts. What were you referring to when you gave that testimony?
In some cases, charges are filed that are simply not supported by the available evidence.
And were you applying that to 11 CR 1575?
If that's the Gilmore case, yes.
It is the Ben Gilmore case. Did Judge Odell classify you as an expert witness in spite of the prosecution's objections?
He did. The only aspect that, oddly enough, he didn't allow me to testify to in that respect was a metallurgical opinion.
Which is your specialty?
Which is the field that I hold my PhD in.
Mm-hmm. Explain what NFPA 921 is, including what the acronym means.
NFPA 921 is a consensus document that was developed by the fire investigation community. NFPA stands for National Fire Protection Association, and people within that organization had become extremely concerned about the very haphazard and non-scientific way in which fire investigations were being conducted, and the number of people who were being convicted on quote-unquote evidence that really didn't stand up to scientific scrutiny. So they went through the very painful and arduous process of coming up with a document that the stakeholders, being law enforcement personnel, attorneys, private investigators, insurance company investigators, that they could all agree to.
And so how long has that NFPA 921 been in effect?
I'm not sure exactly how long it's been in effect. It's probably closing on 20 years at this point.
Wow, so has it become the standard of reference then for these investigations?
It is the #1 standard that is accepted by courts both in the United States and abroad.
What would you say are the two largest hurdles in a fire investigation?
If you are investigating a fire that you suspect may be caused by arson, the two things you have to establish is that it's an arson in the first place, and then after you've reached that conclusion to a reasonable degree of certainty, you then have to try to find out who is responsible for this arson.
Talk about issues with bias in an investigation.
NFPA 921 is very clear that you shouldn't allow it to interfere in your investigation. There are very specific cautions against bias and expectations in that document. Obviously, a person of interest might develop in a case. One did very early on, and this one was not Benjamin Gilmore. And the caution you have to observe is that as you continue on with your investigation, you don't look at everything through a prism of how does this help me establish that this person is guilty. The key question is, can you keep an open mind? Can you allow for the possibility that your initial assessment of this person of interest may have been incorrect and that you should be looking at a different person? Are you willing to let the evidence lead you, or are you letting your expectations and bias guide your interpretation of the evidence?
If you're testing a hypothesis regarding the origin, cause, and suspect in a fire, and the data that you have collected do not add up to your original hypothesis, what do you do at that point?
NFPA 921 is very clear in that respect. You either have to completely reject or at least modify your hypothesis. You cannot shape the facts to fit a predetermined conclusion.
So when you reject or modify that hypothesis, then what's the first step that comes after that modification?
Retest. Retest against the available evidence.
Let's say you walk into the building and you just think, you feel like it's arson, you suspect it's arson. Isn't that already setting up bias?
It is, yes. Yeah, in this particular case, the initial indication, I believe, that was held by the investigators is that it was likely an arson because of the extremely rapid fire spread that was observed in the surveillance video. But you have to be extremely careful jumping to these kinds of conclusions.
Mm-hmm. Talk about negative corpus and how that has been impacted by 921.
Negative corpus is the concept where you can establish that a fire is arson by ruling out all accidental causes. It was a very controversial and hotly debated topic since the start of 921. And ultimately, I believe in 2011, NFPA finally ruled, and as a consensus opinion, that negative corpus could no longer be used because it is inherently in conflict with the scientific method.
And how is it in conflict with the scientific method?
Because you never can say with any degree of certainty that you've truly ruled out all accidental causes. So by claiming that you've ruled them out and jumping from there to an arson conclusion, you leave open the possibility that you may have missed an accidental cause. And what NFPA 921 now encourages, and always has encouraged, is that you look for positive evidence of arson rather than attempting to eliminate accidental causes.
And that's obviously much more in line with the scientific method.
It is, yes. The negative corpus approach was always fundamentally at odds with the scientific method. It was left in 921 for quite a few years because of an insistence by particularly public sector investigators and some investigators working for insurance companies that we would never be able to prove an arson case anymore if we didn't have the negative corpus tool at our disposal. This is incorrect, and ultimately the governing committee for 921 concurred with that assessment.
In the Mason Flats Penny Flats fire, were there any scientific tests performed that identified this case as arson?
Indirectly, yes. The initial suspect that was identified based on the statements that he'd made was taken down to the police station and interviewed at length. His clothing and personal effects were also sniffed by an accelerant detection canine that alerted on several items of his clothing. This is potentially direct evidence, a person who's been in contact with ignitable liquids.
And that initial suspect you referred to, do you remember his name?
I do. His name is Gerardo Salazar.
And do you remember his nickname?
Yes, he went by Clutter.
And so he was identified on the scene, arrested near the scene.
He was identified shortly after the fire because people from occupied Fort Collins called the police department and said that a person was going around basically claiming to be responsible for this fire. He'd also made statements prior to the fire that he was in favor of taking more direct action to garner some more attention and put some more emphasis behind the Occupy protests.
So the prosecution basically, and the officials on the scene who investigated this, basically came to the conclusion that the Mason Flats fire was arson based on negative corpus, And that has been phased out scientifically over the past 20 years at least.
It was formally put out of its misery in 2011, I believe.
And so if you call the cause of the fire undetermined, how does that impact insurance companies and all of that?
Well, obviously it keeps you from taking the next step, which is trying to find someone responsible for the arson if you can't establish that it's an arson in the first place.
Mm-hmm.
Insurance companies, obviously, depending on who committed the arson, can use it as a reason to deny coverage.
Were all possible hypotheses considered in this case?
They may have been considered, but they were rejected without cause at times.
So they were considered but not tested?
At one point, obviously, Gerardo Salazar was a person of great interest to the police department. And for reasons that are patently unclear to me, he was eventually rejected as a candidate.
Mm-hmm. What did you think about the fact that a Rolex watch was found at this fire scene?
It's owned by a person who had no business in that building. There was no particular reason why a watch with his name on it should be found in a building where he's neither an owner nor an invitee.
Mm-hmm. What can you remember about the prosecution's experiment on the scaffolding reenactment?
So the demonstration that was done at best shows that an able-bodied person could climb the scaffold. It has absolutely no scientific validity in terms of establishing that Benjamin Gilmore could have done this.
Mm-hmm.
The district attorney made a very clever argument in this respect by pointing out that Mr. Gilmore was in the habit of climbing ladders. Well, and I believe that may have sown some confusion in the minds of the jury, but if you think about it, the ability for a person to climb a ladder is not nearly as impeded by missing a left hand as climbing a scaffold is. I mean, the good demonstration, the valid demonstration, would have been for a police officer to try to climb this scaffold with his left hand bagged or taped somehow, so he couldn't use it to grasp. I think that the outcome of that experiment would have been dramatically different from what was shown. My biggest concern is that you're showing something to the jury, suggesting that something could have been done a certain way, when the experimental conditions do not match the suspect that you're trying to convict.
Mm-hmm. Were you aware that there were homeless transient people staying in that building?
Yes.
Were any theories tested about how the watch ended up at Mason Flats?
No. Interestingly enough, no. In two respects, that was neglected. There was a kind of a convoluted explanation in terms of how a fire setter might have ended up without the watch. One of the initial explanations was that the fire was so hot that the watch got hot and that a person would have tore it off their wrist to keep from burning. Well, that is completely impossible. If the radiant heat is enough to get the watch so hot that you can't keep it on your wrist, you are on fire at this point. There is absolutely no way that a person could have survived that kind of exposure. So a second explanation that was offered is that it was somehow snagged on a nail. This process was never demonstrated. This was never attempted to be replicated. This was simply thrown out as a possibility without any scientific underpinnings. So that was one aspect in which the watch was not investigated. The second aspect was that a great leap of faith was made in that the presence of the watch on the fire scene somehow equated to the presence of Benjamin Gilmore on the fire scene. I think that's actually the more significant breakdown in the logic.
Mm-hmm. Are you aware of any time that Gerardo Salazar had access to Ben's personal property?
Yes.
How would he have had access to that?
He had access to Gilmore's house, where the watch was kept. He worked for Benjamin Gilmore at times.
You mentioned on the phone when we spoke earlier that this case has kept you awake at night. What exactly has caused you those sleepless nights?
What caused me the sleepless nights is that this is the very type of conviction that NFPA 921 was designed to prevent. It was designed to prevent it by seeing to it that fire investigators would not bring these kinds of cases forward. It is very easy to talk a jury into a conviction under these circumstances. It's the investigator's responsibility to recognize that there's a perfectly valid other explanation for why this watch might have been in the residue, other than a one-handed person climbing a scaffold in the middle of the night and somehow in some convoluted series of events losing the watch, failing to pick it up even though he knows that it has his name on it, and leaving it behind for the investigators to find. I mean, on the face of it, it simply doesn't make any sense.
As you watched the video interview between Gerardo Salazar and the Fort Collins police, what impacted you the most?
I read the transcript from the video. I didn't watch the video itself. What struck me was the great inconsistencies in Mr. Salazar's accounts of where he had been that night, and also the frankness with which he admitted to being an anarchist and an arsonist. That is the critical step that we failed here. Had the procedures and the methodologies of 921 been observed in the investigative stages, Benjamin Gilmore would never have been charged with this crime.
Being Ben's wife is probably the best blessing that I've ever had. He brings out the best in me. He brings out the best in every individual. He makes me very proud. He makes me sad that he's in this situation for helping somebody.
Oh yeah, right, yeah.
I mean, no pun intended, but he's been burned by helping an individual. But he doesn't take that personally. Like, he's still going out and helping. It hasn't jaded him. He's just still trying to be positive that the truth will come out. And we'll move forward with this. We'll be able to continue with our family. Just spread the word that things are not, just because the person is picked up and convicted does not mean that it's true. The media does not paint people accurately. It's all about selling the news. They just sensationalize things.
Good luck, brother. I'm here with you for the long haul.
How do you see your role changing now that he's facing 30 years in prison?
Oh, I don't even want to think about 30 years in prison. This just can't happen. It'd destroy his family, obviously. It'd be devastating. I love you, brother. I'm sorry you got in this mess. And I believe in you. I know that you're doing the best thing you can to be accepting of what God's path is for you and the things you can learn from this. As falsely accused as you are, I know that you have a faith that God is bigger than all this world, and you're holding on to that nicely. It's been an inspiration to see.
And I'm sorry that our criminal justice system failed you.
Is there anything you'd like to add?
It's hard to have trust and faith in a system that fails more than once so miserably in this community.
Please stop playing this game. Allow us to be free.